We have this piece of paper. It's an old law. It's called the Constitution. And then that piece of paper was amended, and that's an old law too. It's called the Second Amendment. And these old laws, of course, are very important. What that Second Amendment does is it gives we, the people, the right to bear arms. There was a Supreme Court case that I've already talked about in a couple other videos called New York Pistol Association versus Bruen. And Bruen turned our little Second Amendment world upside down because Bruen said, look folks, if you're gonna regulate bearing arms, then you have to look at that regulation in light of the historical context of the Second Amendment. And you actually got to go back and see if the regulation that you have right now is legit in light of how that amendment was created and interpreted when it was created. For example, the whole problem in the Bruen case was the fact that New York had, I think it was the city, imposed this law that said, well, you can carry a handgun if you can show proper cause, if you can show a good reason why you need to defend yourself. Well, the Bruen court said, I mean, look at the history of the Second Amendment. Did anybody have to ever jump through that kind of hoop to bear arms? Hell no. For us to look at these laws regulating handguns and guns, we got to use a test that goes back. And in Bruen, that law in New York failed that test and that law got struck down. The reason I'm talking to you about this, I've been doing criminal defense in Florida for over 30 years, is we have a lot of laws regarding the regulation of firearms, in particular when it comes to people who have lost their right to bear arms because they are a convicted felon. People are taking that Bruen decision and saying, did we, back in the day, take away a convicted felon's right to possess a firearm? And in Florida, there has been no case even citing the Bruen decision until the one I'm about to talk about, which is Edenfield versus State of Florida. Edenfield is the first case to bring up Bruen, and Edenfield was charged with ag battery, and he was a convicted felon, and he possessed a firearm as a convicted felon and was found guilty of possessing a firearm by a convicted felon. He challenged the constitutionality of Florida's law that said it is felony for him to possess a firearm. The court in Edenfield said the Bruen Supreme Court decision gives us a couple factors that we have to look at and see how this Florida law jives with how the courts are supposed to interpret a firearm law. So they do this. And let's start this party by just quoting a decision before Bruen, which I also talked about in other videos, called Heller. And that United States Supreme Court decision lays the foundation and says the Second Amendment protects an individual's right to bear firearms. However, the court observed, like most rights, the right secured by the Second Amendment is not unlimited. I get these comments from you folks that is like an amendment to the Constitution is like unlimited food and drinks at the Golden Corral. It is not unlimited food and drinks, folks. There are limits on the Second Amendment. One of the things that Heller said was that the protection afforded by the Second Amendment extends only to law-abiding, responsible citizens. Edenfield says, look, I don't think this felony I'm convicted of, possessing a shotgun, a single-shot shotgun, as a convicted felon, this is not constitutional. I should be allowed to possess this firearm. The analysis goes something like this. You first look at the possession and the law itself. And the possession itself is not some crazy military missile firing weapon. It is a single shot shotgun. And the court in Edenfield said, all right, this is traditionally something that people are allowed to bear arms. This is traditionally an arm that the Second Amendment covers. So guess what happens? They say that at this point, the burden shifts to the state to show the court, under Bruen, the burden shifts, and for the state to prove that there is historical precedent that a convicted felon cannot possess a firearm, right? And this is a Florida court conclusion, is that historically, convicted felons are banned from having firearms. They even cite in Edenfield that a lot of felonies all the way dating back, right? Felonies were punishable by death a lot of times, things that are not punishable by death right now. And they reason, I know it seems like they're going out on a limb here, but they're like, look, back in the day, they were gonna kill you for a lot of these felonies. They had a death penalty for a lot of these felonies. It stands to reason that you're not gonna possess a firearm after you've deceased. Therefore, they were pretty serious about their felonies back then, and we're not gonna let you possess a firearm as a convicted felon, and we're certainly not gonna find Florida's law unconstitutional based on Bruen. The Edenfield case says, look folks, it is still illegal for a felon to possess a firearm. I wanna give you one little tweak, and I'm gonna end it here. But the one little tweak, remember I said at the beginning that the Heller case said law-abiding citizens can bear arms, right? There's a later case in Florida that we'll talk about after the Edenfield that kind of deals with that phrasing. But for the time being, Florida law says convicted felons cannot bear arms. Have a nice day. That's my update for you today on the Second Amendment.